Alright guys, this is Clifford Enoch. I'll be discussing what I studied since yesterday, May 2, 2024. So this is our case, People of the Philippines versus ABC 260708, GR number 260708, January 23, 2024. So what happened here, the accused or the respondent in the case, particularly the naming convention, was changed. So instead of just ABC, they affects the GR number. Anyway, let's proceed. I'll have to close this noise cancelling. So I have here the snapshots of my study. So I'm going to discuss first the history of Article 335 of the Revised Penal Code, and then it was repealed subsequently from crime against chastity. Now crime against person. So as you can see here, Article 335, that was the Revised Penal Code, published or December 8, 1930, is just a simple lang na pagka wording, parang simple lang. I mean, halimbawa, Article 335, when and how rape is committed. So sabi dito is rape is committed by having carnal knowledge of a woman under any of the following circumstances. And if you're going to proceed to the latter reiterations of this particular wording, it was changed. So like for example, in the article in RA 7659, so it's here, it is still rape is committed by having carnal knowledge of a woman under any of the following circumstances. So RA 7659, this is 1993, and then there is a amendments below regarding the death penalty. Alright, so but now comes the RA 8353. It is now the wording is now different. Like for example, rape is committed by a man, compared to before, rape is committed by having carnal knowledge of a woman. So there's no mention of a man. Rape is committed by a man who shall have a carnal knowledge of a woman. And then here's RA 11648. Now it changed to no longer a man, but by a person who shall have carnal knowledge of another person. So there's no distinction now, male or a female, or man to man, woman to woman. Now we go to the central of the issue and the naming or the nomenclature of this case, People of the Philippines versus ABCD 26078. So in here, there is a clarification by the Supreme Court in order for there is a clarity and uniformity. Discussed by, or the ponente is M.B. Lopez, the now bar chairman for the 2024 bar exam. It says here, the court now fixes the guidelines as the proper designation of the offense. So whereas before there is a naming convention, it was stated there qualified statutory rape, but it should now be qualified rape of a minor. So number one, there is number one here, the crime shall be denominated as qualified rape of a minor and not qualified statutory rape if any of the special qualifying aggravating circumstances is present. Like for example, twin circumstances of minority and relationship, or the age of the victim being below 7 years old, or so the third one, or the accused knowledge of the mental disability of the victim at the time the commission of rape. And regarding this rule, it shall apply whether the victim is below the statutory age or suffering from mental retardation comparable to the intellectual capacity of a child below the statutory age. So here, there is an element of mental retardation. The second, denominated as qualified rape of a minor and not qualified statutory if the crime is attended with two or more special qualifying circumstances. So here, any, but here is two or more. So like for example, na lumabas din siya the same with the first one is twin circumstances of minority and relationship, or the age of the victim being below 7 years old, or the accused knowledge of mental disability of the victim at the time of the commission of rape. So actually, this should be nice if I'm going to make this like this. This one is the if any, but this one is two or more special qualifying circumstances. And then the examples are the same, A, B, C. Okay, so in this one of these aggravating circumstances is sufficient to qualify the crime. And then the unutilized special qualifying aggravating circumstances will be deemed as generic aggravating circumstances, which may be appreciated if the facts warrant the imposition of a divisible penalty, i.e. existence of privileged mitigating circumstances under Article 69 of the RPC. So let's tag the article. So under Article 69 of the RPC, penalty to be imposed when the crime committed is not wholly excusable, and the penalties in cases of prostrated and attempted felonies, and for accomplices and accessories pursuant to Articles 50 to 57 of the Revised Penal Code. Articles 50 to 57. 50 to 57. Penalty to be imposed upon principles of prostrated crime. This is the prostrated, attempted, and the consummated. 1, 2, 3, up to 57. Otherwise, any unutilized aggravating circumstance shall not be considered in the application of penalties. So the term statutory age in this guideline shall mean either below 12 years old if this is before the effectivity of RA 11648, or under 16 years old after the effectivity of RA 11648. So, my prediction, this case will appear in this year's bar exam in criminal law. And that's it. Thank you.